Good evening. Welcome to Illinois Law, brought to you by the Illinois State Bar Association. I'm Nancy Hablitz, and I'm your moderator this evening. We're going to talk about discipline of students who have special education needs under the Individuals with Disabilities Education Act. I have three panelists who know a lot about this topic. The first is Mary Klimisch, who is a partner at Seyfarth Shaw in Chicago. She's a member of the Executive Council of the Illinois Council of School Attorneys and has been representing public school districts for approximately 20 years. Her practice focuses on public sector and education law, including the breadth of issues raised by Titles I and II of the Americans with Disabilities Act, Section 504 of the Rehabilitation Act, as well as the Individuals with Disabilities Education Improvement Act. My second panelist is John Dively. He's professor and chair of the Educational Leadership Department at Eastern Illinois University. He teaches courses in educational research, school community relations, and school law. He has been a practicing attorney, a school administrator, and the executive director of a statewide principals organization. And my third panelist is Deb Decker, who is a partner at the commercial litigation firm of Tabbitt, DeVito, and Rothstein, LLC in Chicago, where she handles a wide variety of commercial litigation matters at both the trial and appellate levels. She also represents parents and children on issues involving school law and is on the board of directors for the nonprofit association Autism Alert. Deb is a member of the Illinois State Bar Association's Education Law Section Council and serves as its secretary this year. Welcome to all three of you. This is a topic that I know is of tremendous interest to any parent who has a child either identified for special education needs at this time or who might be eligible for special education and may or may not have been identified. So we're going to talk a little bit about both of those. Just starting with this, what are the basic differences between discipline of a child in regular education and discipline of a child in special ed? Do you want to start with that one, Deb?
Sure. I think one of the major differences is that there oftentimes a child who has special education needs will exhibit certain behaviors that don't require discipline. Instead, they require the tools that that student might have in an IEP, or that student might need an IEP to address these behavioral problems. And therefore, there's what's called a behavioral intervention plan, which is often used for special education students in order to get their behavior right.
And just in terms of how those go, Mary, let me start with you. How do you get one of these plans? How do you design it?
Well, typically, a behavioral intervention plan is part of the IEP process, and the team of professionals who make decisions regarding the programming needs of a student will meet, and they'll talk about whether or not a student is in need of a behavioral intervention plan because the child's behaviors is regularly impeding their ability to be successful in school or learning in some way. And the team will make a decision, and they will conduct what is called a functional behavioral assessment to determine what kinds of behaviors seem to have a pattern or some level of predictability which might be appropriately addressed through a behavioral intervention plan, which basically says this child engages in this behavior in science class on an every other day basis. There might be something that is occurring in that environment that could be addressed, for example, and the science teacher and the team might work together to see what they could do to address that behavior. Or it may be more global in scope to help the team identify behaviors when they are occurring or even before they occur, so that they can present the student with some level of activity to keep the misconduct from occurring.
And just from the standpoint of a school, what's the organizational structure or the procedural structure for doing the functional? Who does it, and how would they do it? How would a parent approach getting this done?
Right. This is going to be done through the IEP process, and or as an extension thereof. You've already got the IEP in place, so we want to go back and look at the behavioral intervention plan. This would be something that probably would be raised most likely by a teacher who would indicate that a student with special needs in their classroom is having some difficulties, or it may also be raised by an assistant principal who's noticed that a student has been sent to him or to her on a number of occasions. But it can also be raised by a parent. And so based on that information, then, we would want to go back to our team, as Mary had pointed out, and look at what are some of the other options that might be available in helping this student. Because they do have a disability. This isn't something they're choosing to do. It's something that is a part of them. And so then how can we accommodate them in some way to make their experience and the experience of those children in that other students in that classroom better?
And if you were a parent asking for a behavior intervention plan or a functional analysis, what would you expect to have done, or how would you ask for it?
I think the first thing is to educate yourself in terms of the special education program and how it works and who's part of the team. There may be circumstances where you may not have that right member of your team that can actually administer the functional behavioral assessment. And so one of the keys in special ed is you want some sort of research-based mechanism for figuring out, number one, what the problem is, and then number two, how to solve it. So as the parent, you want to get as much information as you can about who's going to be involved and whether there's a need to bring somebody into that IEP team to help out.
And would the person who goes in to do the functional assessment, is that typically someone who's brought in with who has special training, or is it just another teacher or the principal, or how would you do that?
It typically is somebody who has special training. It can be a variety of people. It could be a social worker, it may be a behavioral specialist, it could be a psychologist who does the functional behavioral assessment, or it might be a group of teachers meeting together collaboratively to try to identify certain kinds of behaviors or patterns of behaviors through questioning that is presented by an individual who has been trained in completing a functional behavioral assessment.
Would it typically be done over a period of time so that you could get various sort of snapshots of the child?
There isn't really a typical approach for us to sit here and suggest to you this is what a behavioral functional assessment looks like. There's a lot of latitude with respect to functional behavioral assessments that range in time from 1 or 2 observations to questioning teachers to a combination of maybe a series of lengthy observations of a child. Again, it depends upon the kinds of behaviors that are presenting as problems in the school setting and the kinds of systems that are in place for addressing those behaviors. Clearly, the law would envision that there would be appropriate responsive measures taken to address it so the student can be successful and acquire an education that would allow the student to progress in those goals and objectives in the student's IEP.
And that would be basically the behavior intervention plan, the plan that's drafted
Correct.
based on the functional assessment. Would that be something that would be drafted then by the whole IEP team?
Yes, we want input from all the stakeholders involved. We'd want everybody's input on that, certainly.
Okay, we're going to talk a little bit more after our break about some of the other disciplinary issues for children with disabilities, and I want you to think while we're taking our break about some of the perhaps procedural issues that have to be followed when you're either suspending a child or redoing his IEP. We'll be back with you in just a few minutes with my 3 panelists talking about discipline of students with special education needs. My name is Nancy Hablitzel, and we'll be back with you in just a few minutes.
Hi, Tyler.
Dear, it's time for serious talk
Oh?
about my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never! Mister!
Over and over,
Come on! It's our Leave me alone! Shut up! Out!
time and again,
No! Drive me nuts! Shut up! You're the dumbest
generation after generation.
I hate you! I hate you too!
Isn't it time we stop the cycle? Now.
I hate you! I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law. My name is Nancy Hablitzel, and I'm here talking with my three panelists about discipline of children under the Individuals with Disabilities Education Improvement Act, Children in Special Education. My three panelists are Mary Klimisch, John Dively, and Deb Decker, and we were talking about the steps that you would take for children who have special education needs. Let's talk about when they do something that's really serious, something that would put someone, either themselves or someone else, in danger. Mary, what happens?
Well, it depends upon what the conduct is, and of course there's some options that would be available to the school district. Under the Individuals with Disabilities Education Improvement Act, they anticipate that there are certain kinds of conduct that are so severe that it allows school officials to remove the student from the regular setting or the setting that has been established by the student's IEP into what is called an interim 45-day school placement. And those behaviors that would warrant that immediate removal would include bringing a weapon onto school premises, bringing drugs onto school premises, and engaging in serious battery behavior where there is injury that has occurred to either another student or a teacher. And in each of those three sorts of categories of behavior, the school can take that action to remove the student immediately to an interim placement. While that's occurring, and even if the school does not proceed to take that measure, the school would have the authority to consider disciplinary response. And that typically would include, for serious misbehaviors, suspension and/or a recommendation to expel. For special education students, the school district can suspend the student for up to 10 consecutive school days from school without any educational programming, so long as it doesn't exceed 10 school days in the entire school year. And so for special education students, that is another option available for school districts. Expulsion of students can also occur. However, if there is a recommendation to expel, there needs to be held what is called a manifestation determination review meeting. That is when the IEP team comes together and they make a determination as to whether or not the student's conduct or misconduct is related to the student's disability. If it is related to the student's disability, the student cannot be expelled from school. And there can be a consideration of a change to the student's IEP, a consideration of the student's change to the student's placement, but the student could not then be expelled from school.
And we talked earlier about the use of a behavior intervention plan or so on. Could that be one response if it is a result of their disability?
Yes, if it is a result of their disability, then we're looking at implementing a behavioral intervention plan. If it's not a result of their disability, then basically it is treated as though it's a regular education student. In other words, if it's a discipline problem rather than a problem related to the disability.
Mm-hmm.
And could it ever be treated with, say, just additional special education services?
I suppose it could, yes.
Would that be an appropriate modification if it is a part of the disability or result of the disability?
Yes, if it's a result of the disability, I think then what the IEP team is going to do is try to figure out how to solve that problem, how to correct that behavior so that the student can take the best advantage of his education.
And,
And in fact, the law actually requires that school districts meet to engage in looking at the behavioral intervention plan, and it needs to be addressed to do what can be done to try to prevent that kind of conduct from recurring in the future.
Is it ever cause to take a child and move them into a different placement?
Oh, yes. In fact, many schools take the approach where we're not going to go to an expulsion of a special ed student. What we're going to do is if they get up around 5 or 6 days external suspension, we're going to call the IEP team back together and say, look, whatever it is we're doing doesn't seem to be working. Let's look at a change of placement so that before this child gets to that 10-day limit.
And what kinds of placements might they look at then?
There are a whole variety of placements, of course. You know, it just runs the whole continuum there. But you could require them to spend more time in a especially if you're looking at an emotionally disordered student, more of a self-contained classroom. Or then also there could be some self-contained classrooms that would be off campus in another location as well.
Can you ever just move a child very quickly in an emergency situation?
You can get injunctive relief in the case where a school has reason to believe that a child is a danger to themselves or to others. Or, as Mary's pointed out, under the 45-day unilateral placement in cases of the 3 incidents, the weapons, the drugs, or serious bodily injury.
What happens while the child's in that 45-day placement? What do you do while the child is there?
Well, the Act actually requires, the law requires that any interim placement that is instructional or part of the interim placement would need to be able to implement the student's IEP in the same way the IEP would have been prescribed before the incident occurred. So the curriculum would continue, the interventions would continue, the placement would be different. And in some instances, there may be additional interventions. There may be social worker, counselor that's also assisting in intervening to assist in addressing the misconduct or incident.
Would there ever be additional diagnostic work done while the child is out?
Yes, and in some instances, parents may request that additional diagnostic information be gathered as well to determine or to help in evaluating the reasons for the behavior's recurrence, trying to develop a better understanding of the individual student's needs. So diagnostics clearly are a consideration for the team to consider when misconduct has occurred.
And would a child typically from the 45-day placement go back to the original placement or typically be sent somewhere else, or does that vary?
I mean, I think it depends on the circumstances, and certainly when the 45-day placement is really kind of in a crisis situation. So a lot is going to depend on what happens during that 45 days. As Mary said, diagnostics might be done. There might be a need for the IEP team to reconvene and talk about what to do next with that student.
Would it also depend on what the infraction was?
It could. I think the whole idea of having as much as 45 school days is to give the IEP team and the family an opportunity to work together to try to figure out a plan while giving the school some opportunity to have this child removed from a setting while everybody is figuring out what the next step should be in terms of developing a more appropriate IEP for the student after having had knowledge of some serious behavioral infraction or misconduct.
So it's more than of a therapeutic response as opposed to a punitive response. A safety response.
It's a
maybe.
safety response, and the response is measured in light of the student's individual needs rather than a punitive response dictated by a student handbook is typically what the considerations are.
And I think that really the student handbook for all students, including special education students, it's not designed to be punitive. It's designed to correct behavior. And that's something that's really important in special education students, as well as all students. With special education students, sometimes what you have to deal with is their special needs and having those addressed in an IEP.
And I think this goes to something that John said before on one of our other shows, which is that what we're really looking at is the child's educational placement and making sure the child can learn whatever his special needs are, and that you'd want to focus back really on getting them back into an educational program. Would that be right, John?
Exactly.
Am I quoting you correctly?
Absolutely. In fact, you said it better than I said it myself.
No. But I think that was sort of the gist of what you were saying.
Yes, it was.
If you're looking at this then from the standpoint of a parent or a teacher, one or the other, working with a child in a serious situation like this, what would be the first thing that you'd want to look at? Would it be what happened at that moment? Would it be at the child's needs? Is it all of it?
Well, you know, especially when you're looking at one of those big three there may be some other entities involved as well. I mean, if you're talking about bringing a weapon to school or drugs to school, or there are going to be some other entities that are going to be involved here as well. So probably the first focus would be addressing the criminal component of it. But certainly, students make mistakes that they can rebound from, and so the school component is critical as well and can't be overlooked. It's really the whole thing has got to be worked at. I know that all of us have been in situations like, your heart goes out to parents in those circumstances, but I think they need to understand the school is there to help, but also our responsibility is to keep all students safe as well.
And any final words for parents who might be in this situation?
I just would say, again, our hearts go out to you, but you have a partner in the school, and we want to see your child be successful. And so we have many resources that are available to you. And so this shouldn't be perceived as an adversarial relationship. We're on the same team. We want to see your kids succeed.
Sort of ask, what help can you give me?
Absolutely.
And there's typically, with respect to special education students, you're going to have a special education administrator involved, as well as the dean of students involved. And they can afford the parent an opportunity to learn more about their rights and their child's rights with respect to what procedures they are due with respect to the particular incident.
Thank you so much to all three of you. It's been great talking about this, and I'm sure that our viewers have enjoyed it too. Thank you to all three of you, to Mary Klimisch, John Dively, and Deb Decker, and thank you for watching. This has been Illinois Law, brought to you by the Illinois State Bar Association.